co-panel today. Guest of honor, Justice T. Madhavi Devi. All my
I was mesmerized listening to her.
friends, judges, cheerleaders over here. Justice Shravan Kumar, Justice Moinuddin, Justice Chalapati Rao, Justice Ramakrishna Reddy, and of course, last but not the least, Justice Praveen Kumar.
Okay.
The additional Solicitor General,
Okay.
my personal favorite always. Then, of course, how can I forget the President of the Nyayavadi Parishad High Court Unit, Mr. T. Srikant Reddy. He gave me very important inputs of the Nyayavadi Parishad. Then we have the National President, the State President, the State General Secretary, the State Secretary, and the Vice President High Court Unit. I can see the learned DSG, the Deputy Solicitor General. I can see Mr. Prabhakar, Mr. B. Narayan Reddy. Mr. Prabhakar often appears in our court. Ms. Rachna Reddy, and all my favorite advocates from Kalyani to Rajalakshmi to Mahalakshmi to Pranati, everyone sitting over here. If I missed anyone, sorry about that. So thank you very much for giving me the opportunity to come here and address all of you. And I'm so very happy to see the very nice and fresh faces of students who are sitting here, waiting for this, participating in this very important function, program. And Mr. Srikant Reddy Garu was actually telling me that this is one of the important programs which is organized every year. And I am happy to be part of it. We were all waiting in the anteroom, I was also given very important insights by the learned Additional Solicitor General about not only the Nyayavadi Parishad but also the Keshava College, that there are 4 law colleges, 4 colleges, 16 institutions.
Wow.
That so many of you have qualified recently for the junior civil judges posts. That the Keshava Trust, the Nyayavadi Trust, your seminal contribution in the nationalist movement, in fostering a spirit of justice, in fostering a spirit of equality, in taking forward the spirit of seeing our country, realizing the value and worth of our country, and realizing most of all that the spirit, the ethos of democracy, the spirit of equality, non-discrimination, originated in India much before, long before the Western countries. So this is such an important work which the Nyayavadi Parishad and the Keshava College, the Keshava Trust, all the institutions under the umbrella does, and I'm very proud to be a part of it. So I have, and I missed, but I'm told that Justice Narasimha Reddy left, but I was very fortunate to interact with him while we were waiting to come here. So I will not give a long speech, but I have a prepared speech because I wanted to bring forward a little bit of data, a little bit of statistics to show where women were and where women have come forward today. And I leave it to you to assess whether there has been progress or there is more work to be done, or whether we should be proud of our achievements. So that assessment is not mine, that assessment should be yours. But what I wish to present to you today evening, is a little bit of statistics, and that's why I thought I'd give you a prepared speech. Of course, we all enjoyed Justice Madhavi Devi's spontaneous words. So I will just give you a brief roadmap as to the 4 topics I intend to cover. Short time I will take. The first topic is ancient India. Ancient India under the Vedas, the Upanishads, and even Ramayana and Mahabharata. How were women placed in ancient India before we thought or conceived of courts, of law, of institutions, colleges, academics? The second topic will be early struggles of women. And when I say early struggles, I want to make it a bright and a promising and an optimistic topic and not really leave it to the struggles, but from exclusion to entry. That's what I would like to focus on, that the transition of women from exclusion to entry. The third will be the contemporary landscape of women, and not only the contemporary landscape of women in relation to courts, but also very important, legal education with regard to the legal profession, the judiciary and the academics. So I will first start with women in ancient India, and it was really, while I was doing a little bit of research for today's talk, over the last 3 to 4 days, I did not get much time because I was in Calcutta for the long weekend, came back to Hyderabad on Sunday night. So under the Vedas, so interesting because I also learned so many things. Under the Vedas, you had Lopamudra, who was a Rishika. And Mr. Srikant Reddy Garu actually mentioned the word Rishika in his speech, who was a Rishika, that's a female seer, and who was also known as Brahmavadini, and a woman of doctrinal authority. She was the wife of Agastya Muni, sage Agastya,
about all the Vedas,
and one of the 27 women credited as authors of the Veda, of the hymns in the Rig Veda. She established a female voice in formal debates when she and Agastya Muni, her husband, engaged in a proper rational debate known as Brahmodaya, which involved discussions about logic and desire of the human mind, desire of the human heart. And we also have, under the Vedas, Apala, who was a young woman and also a Rishika, and who wrote a hymn in the Rig Veda and addressed it directly to Indra the god, petitioning Indra for healing and justice of Apala, of herself, without a male intermediary. So the Vedas projected Apala as the first woman who directly prayed and petitioned, like a petition we file in court, to Indra for her own salvation, for her health. And this was the first earlier form of an individual legal standing as we see today in courts. And prefigures also the concept of locus standi as we understand under Article 226 of the Constitution. In all writ petitions, one of the first questions which is raised is, do you have locus standi to file the writ petition? Under the Upanishads, we have Gargi Vachatnavi, who was a philosopher scholar and participated in King Janak's, Raja Janak's great Brahma Sabha, or in other words, a philosophical assembly. And according to Brihadaranyaka Upanishad, she challenged sage, a very important Muni Rishi, in a public philosophical debate before a full assembly of scholars at King Janaka's court about a chain of logical questions and answers, pushing him to the limits of metaphysical knowledge. And this was the first instance of a cross-examination, as we see in any of the suit courts today in India. And this was also the first structured questioning with regard to burden of proof, who has the onus of burden of proof and who has to discharge that burden of proof. We come to the Ramayana. In Ramayana, you're all familiar with Ramayana and Mahabharata, but I just picked 4 examples, 2 from each. First of all, Sita's demand for due process. So after the fall of Lanka, when Lord Rama questioned Sita's chastity and questioned it in public before an assembled army and allies, rather than submitting, Sita delivered a structural rebuttal, and I'm deliberately using words which we are familiar in our courts now. So Sita delivered a structural rebuttal invoking her rights and her character as evidence and demanding that the ordeal be conducted in accordance with a proper due process. And Sita argues, that she cannot be punished on suspicion alone, but that she challenged Sri Ram to prove the accusation rather than a presumption of guilt on the part of Sita. We have the other example in the Ramayana, that is Tara. Tara's argument under unlawful combat, that is the Kishkinda Kanda, which we know, which we are all familiar with. When Bali, king of Kishkinda, is about to fight Sugriva, Tara intervenes. Bali's wife Tara intervenes and delivers a detailed strategic and legal argument against the fight, warning that it is being conducted unfairly and under improper conditions. Tara's challenge mirrors the principles of natural justice, that when you fight an adversary, there must be level playing field between the two. We come to Mahabharata and the incident which all of us from childhood are so familiar, and it is as part of our consciousness in some form or the other. That is Draupadi's jurisprudential plea. I repeat that I am using words deliberately to connect it with what we are facing every day in courts. So Draupadi's jurisprudential plea, that when she was being staked in and lost, and Yudhishthir lost in the dice game against the Kauravas in the fort, Draupadi was dragged into the Kauravas' assembly by Dushasana at the order of Duryodhana. And rather than weeping or pleading, Draupadi made a precise jurisprudential question to the entire assembly, and I am just using it within quotation marks. If the king had already lost himself first, by what right did he stake me? Let the Kurus speak the law. Let them give an answer.
You're following her.
She also questioned, Draupadi also questioned, a king who has himself been reduced to slavery, who has accepted bondage as his own condition, by what law can such a man then stake his wife? If this is to be decided by dharma, let the entire assembly answer this question. So I just wanted to, because when I was reading this, I felt goosebumps. I felt a kind of an inner fire, that all the legal concepts which we discuss now in courts, we look back centuries, we look back into our Vedas, we look back into our mythological stories, the Ramayana, Mahabharata, and we find answers there. All these judicial concepts we find can be traced back to these stories. So I go to my second chapter, which is early struggles from exclusion to entry. And of course, we are all aware that women have historically faced so many barriers when it came to not only participating as professionals, as lawyers in courts, but also with regard to the perception, with regard to when the President very rightly told us that what is required is the perception. is the equality, is the change of mindset. So, and law somehow was always perceived of as a very male, quote unquote, male profession, male preserved, where women were thought to be somehow inadequate, not only in terms of their capacity for hard work, but also their capacity of understanding a legal problem, their capacity of articulating what they felt, and their capacity to write, to articulate their thoughts in terms of a written judgment. So somehow women always were looked upon as unequal to men, where women in the legal profession were somehow the weaker sex, and the men were the stronger sex, because legal profession itself was looked upon as a male preserve. Now, when in India, formal education in the stream of law was introduced as early as in 1855, 1856, 1857, with establishment of universities with law departments in the University of Calcutta, in the University of Bombay, and the University of Madras. And the University of Calcutta was actually established in 1855, and this was before India gained independence from British rule, which was much later, 1947. And in those days, the legal profession in India was treated as a man's area. And before the year 1923, while women could study law, they were kind of, there was no bar on women from studying law, but they were not allowed to enroll as advocates. And the singular reason for their disqualification of women enrolling as advocates was only their gender. That means only the fact that they were women. So you can see the dichotomy. So while they could study as lawyers, they could become lawyers, they could not be enrolled as advocates. So there were some notable women, even as far back as in the middle 19th century, we are talking of 1856, 1857, that women like Regina Guha, Sudhanshu Bala Hazra, and Cornelia Sorabji had to fight a very hard and protracted legal battle by way of a social movement, not only their personal battle, but also they kind of took other women in that battle and made it a social movement, and which led ultimately to the promulgation of the Legal Practitioners Women's Act 1923. That act entitled women for the first time not only to be admitted, but also to be enrolled as legal practitioners. But even after being admitted into the legal arena, the presence of women was actually extremely negligible till the 20th century. The step forward when women started becoming visible, when their voices started becoming heard for the first time in the 20th century, we had Cornelia Sorabji. And my favorite quote, my personal favorite quote from Cornelia Sorabji is, "When the doors were closed, she didn't knock on them, she broke them down." So that is a very inspiring quote. And Cornelia Sorabji, as you all know, was the first woman to pass the civil law examinations in the UK in 1892. But despite passing the bar, as far back as in 1892, she was not allowed to plead before the Allahabad High Court, because at that point of time, the legal profession was only restricted to men, not women. 24 years later, or at least in 1916, that's not 24, that is much later probably, in 1916, Regina Guha's enrollment application was rejected by a bench of 5 judges in the Calcutta High Court. And the Calcutta High Court in 1916 gave the reason for rejecting Regina Guha's application for enrollment to the bar, saying that as the law stands, this is within quotation marks, I just took it from the judgment, as the law stands, a woman cannot be enrolled as a pleader. The judges actually wrote this. And legal practice then was governed by the Legal Practitioners Act of 1879, and Section 5 of that Act said that no person shall appear, plead or act as a pleader unless he has been admitted and enrolled, while the Act of 1879 did not contain an explicit bar against women from becoming pleaders. There was no mention. The Act continued as he. You can of course argue that